Many factors are involved in determining custody in Tennessee. But is there the possibility of the child being able to choose which parent gets custody? However, it may not be a clear yes or no answer. The child certainly can have an opinion on the matter. Welcome to Miles Mason Family Law Group. What is the legal age that a child can choose which parent to live with in Tennessee? Can a child decide which parent to live with in Tennessee? No. In a divorce where custody is disputed, the court decides if one parent gets sole custody or if parents have joint custody. With joint custody, the judge also determines who the child will live with most of the time. That is, who will be the primary residential parent, or PRP. The other parent will have scheduled parenting time as the alternate residential parent, or ARP. Given the importance of this decision, older children may weigh in on the matter. How old does the child have to be to choose which parent to live with? In Tennessee custody law, the court must consider the preference of a child who is 12 years old or older. By age 12, most children possess the maturity needed to express a thoughtful opinion on this. We are only talking about a child's preference to live mostly with one parent over the other. This is not the child making a final decision. The judge considers many custody factors. The child's wishes for which parent to live is only one. A minor's opinion is neither conclusive evidence nor determinative of the outcome. In addition to being at least 12, the child must express a reasonable preference. The reasonableness or unreasonableness of a child's preference is a legal question. It's for the judge to determine based on the unique facts and circumstances of the case. In our experience, almost all judges will choose not to allow a child under 12 to express a preference. What about children under 12? Do they have any say in this? Sometimes they do. The judge may hear a younger child's parental preference, but this is purely discretionary. It's entirely up to the judge. The 12-year-old's or teenager's preference is communicated directly to the court. This is the child's opinion about the most desirable living arrangement. Although the judge listens to what the child has to say, there's no mandate to do as the child wants. There is a distinct difference between the judge hearing the child's preference and the child deciding which parent to live with most of the time. This is still a child, and children don't always appreciate what's best in the long run. The judge considers many factors before determining what's in a child's best interests. While the child's wishes are a factor the court must consider, the younger the child, the less important that child's opinion will be. Normally, the court gives greater weight to an older child's preference. Of course, no two children are alike. On average, though, an older child is likely to be more mature and more capable of assessing the situation and making a reasoned conclusion. Most judges will publicly say the preference of a 16 or 17-year-old is much more important than the wishes of a 12 or 13-year-old. The child is not required to choose. Divorce can be hard on kids. Many children may resist voicing a preference. Because they love both parents, they want to live with both parents. No child should be pressured into taking sides. This could devolve into a child's choice between the permissive parent and the disciplinary parent, especially with teenagers. Don't try to lobby the child into choosing which parent is loved the most, or which is more worthy of the child's presence, or more needy of the child's affection. In Tennessee divorce, even an unemancipated 17-year-old can't choose with finality which parent to live with. Parents may agree to a proposed parenting plan in keeping with their child's wishes, but the final determination is still the judge's. We hope this video has provided some insight on the child's impact on divorce. For more discussion on this subject, see the link below to Miles Mason Sr.'s Tennessee Bar Journal article, reprinted on memphisdivorce.com, Don't Make Her Choose: Why Parents Should Never Ask Children What Visitation They Want. To learn more about our firm, visit us at memphisdivorce.com. Tennessee's most comprehensive free online family law legal resource. MemphisDivorce.com answers hundreds of frequently asked questions on divorce, custody, child support, and more with videos, and hosts our Tennessee Family Law blog. Download our free Tennessee Child Support Calculator app, available from iTunes and Google Play. Check out Miles Mason's author page on Amazon.com. He is the author of 3 books, including Tennessee Parenting Plans and Child Support Worksheets, with examples from real cases. Discover all you can learn with Miles Mason Family Law.